And as South Africa pursues its legal bid to have the actions of Israel in the war with Hamas declared a genocide, we ask what the prospects of that bid are in the International Court of Justice. And Wits Law School visiting professor Dr. Mia Swart, an expert in these matters, joins us now. Good evening, Mia, and thank you very much for your time. Welcome to the program. Let's just perhaps explain a little further exactly what South Africa is seeking from the ICJ.
Right. So South Africa, good evening, Iman. South Africa is seeking an order of provisional measures, which is essentially an interim order that can be requested while a case is pending. So this is something that happens fairly regularly before the ICJ when a state feels that, emergency measures, in a sense, are necessary, that, one cannot wait years for a case to be adjudicated. And South Africa is asking for 9 such provisional measures, including that Israel immediately desists from military action, that Israel desists from committing acts of genocide, that Israel doesn't destroy evidence pointing to or proving that genocide has been committed. So there's a whole list of 9 demands, and it is very sort of bold and, I think clever of South Africa to bring it at this stage early in the year, at a time when, there's no reasonable prospect of a ceasefire. This is one mechanism that an international court is allowing for that can, kick in on an urgent basis.
All right, so just to understand, it sounds like there are 2 processes, Mia, just to confirm that is the case. So an interim order, and then there would be a longer procedure to actually pursue the case of, of declaring that this is a genocide that's in play. We heard from our reporter, Alex Cartier, a little while ago, saying it's complex and could take years to resolve. So just talk to us about these 2 pieces.
Right. So a provisional measure is the equivalent of what would be called an interim order or an injunction in a domestic system. It is actually something that can be ordered next week already. And, there would be, as your reporter just said, some enforcement mechanisms attached to this, that the Security Council would have to, call on Israel to implement these measures. If these measures are ordered and Israel refuses to implement them, they cannot just, it will not be ignored, because the Security Council can then call on Israel to actually implement this. Whether Israel will even at that point, comply is another matter. But, at least this is a very high stakes, very high profile procedure, and Israel will be in the spotlight very much.
How do you
the matter on the substance
Sorry, go ahead,
can
Mia.
draw out for many years. We saw in the recent matter concerning the Rohingya minority in Rakhine State in Myanmar, that matter on the substance, is still going on, and it was initiated in 2020. The provisional measures in that case was ordered in 2019. It also involved genocide, but, the case on the substance is still going on. So, it wouldn't be satisfactory to only bring a case on the substance. And one thing that is important here is that if the court orders provisional measures next week, it doesn't necessarily mean that the court says or states or finds that genocide has been committed. This is still a process the court would have to go through in its case on the merits, but it would be a very strong indication that it believes that there's evidence that genocide has been committed.
Well, let's talk about the evidence then, Mia. How do you prove that Israel has the specific intent to destroy a national, ethnic or racial group?
Right. So this is one of the most difficult things to prove in international criminal law. Genocide is notoriously difficult to prove because intent is such a vital core requirement. But in the case of the Israel-Gaza war, Israel, you and I have spoken about this before, Israel has actually been, quite helpful in the sense that it has, made these sort of shocking pronouncements calling Palestinians human animals. It has referred to Israelis as people of the light and Palestinians as people of darkness, and many, many countries have already called this genocide. So I don't think that this will be as difficult an exercise as it often is.
What, Mia, is the wider international significance of this application that South Africa is making to the ICJ?
Well, first of all, South Africa is being supported by a long list of countries ranging from Egypt to Brazil to Colombia to Jordan. South Africa is actually, being seen as very principled and proactive in this matter. So it is good for South Africa's international image. And it is also interesting that Israel has opposed this so fiercely, because if they really have, nothing to sort of hide, if you will, or be fearful of, they would probably not have attacked the South African government that strongly, because a court procedure is also an opportunity to show one's innocence. The wider international repercussions, of course, remain to be seen, but I think that, this is the strongest measure taken by any country so far in terms of trying to effect a ceasefire in an innovative legal way.
This is certainly something that's captured the world's attention as well, Mia, and we will follow developments very closely with your guidance as well. Thank you very much for your time and your expertise tonight. We appreciate it. Wits Law School visiting professor, Dr. Mia Swart.